Good afternoon. Thank you for joining us today. This webinar, Regain Your Freedom Legal Webinar Part 2, will begin momentarily. Longevity Plus and Dr. Gary Gordon do not provide medical advice, diagnosis, or treatment through this webinar. The content of this webinar, such as text, graphics, images, and other material contained within, are for informational purposes only. The content is not intended to be a substitute for professional medical advice, diagnosis, or treatment. Always seek the advice of your physician or other qualified medical provider with any questions you have regarding a medical condition. Never disregard professional medical advice or delay in seeking it because of something you have read, heard, or seen in this webinar. Any opinions or suggestions made during this presentation are the sole opinion of the speaker. Welcome, Dr. Gordon, Dr. Rowan, and Ron McDonald.
Welcome, everyone. I'm so glad that you've been able to join us. I'm Dr. Gary Gordon. Many of you have come here because I have personally sent you an invite to learn about how we can regain the freedom that made America so powerful. You will be hearing from Ron McDonald, and in way of introduction, you need to know that I have seen cases that Ronald McDonald became involved in, which unfortunately, as he is not an attorney and he will not be able to represent you, but the knowledge that he can impart to you can empower you to do something like this impossible story. We have a gentleman who in California is on probation, 5-year probation, and he winds up with a clear-cut open and shut violation, which is a mandatory jail sentence that he faces. As it turned out, he was lucky enough to be rescued by Ronald McDonald, who taught him what the word jurisdiction is all about and how you can't win anything today largely on the merits of the case, but when you can challenge jurisdiction with knowledge, you change the outcome. In an impossible case where he would have had to go to prison was dropped like a hot potato by the court. So the power of knowledge that we wish to impart to you is today a teaser. When you come to San Francisco, it's the whole meat and potatoes, but it's not the kind of thing that you can dump in the lap of your friendly attorney and expect him overnight. It would be like taking the leading heart surgeon of the country and expect him to become overnight an expert in alternative treatment of heart disease. So with nothing more said, I just want you to know that we all know we're in trouble. There are answers. The answers require us to take personal responsibility to learn about where did our rights come from. And with the next voice you're going to hear, Ronald McDonald, and we have Dr. Robert Rowan on with us, who will chime in to try to make this relevant to many of you who are healthcare professionals, whether you are a multi-level company that needs to stop FTC or take on FDA. It is all the same principles. Everybody needs to know the knowledge that we are giving you the glimpse of today. And we started 2 weeks ago by telling you that without understanding the currency issue, you won't even be able to achieve any kind of standing because you are not a free person without a gold coin. So with nothing more said, please turn this over to the presenter becoming Ronald McDonald.
Good afternoon, everyone. Of course, I am Ron McDonald. Today we'll be discussing rights. We'll bring in some case law concerning police powers and how they're to be used unconstitutionally and how they're to be used constitutionally. And we'll eventually end up with a case that I've done over licensure, proving that an individual did not need the license from the state and was able to continue his practice of his arts. So getting into it, we start with the first slide, and it's rights. All rights come from God. And I don't care if you believe in God or not, if you want to have those unalienable rights, you have to address this one issue, that they do come from a creator and they're endowed in you as your birthright. What the state gives you is privileges and immunities. They try to replace every right you have from the Creator by a repealable by an amended type of privilege and immunity that is directly controlled by the state. That's not what we want. As you can see in history, we had the Magna Carta, and it said free man shall be dispossessed of his liberty. No free man shall be dispossessed of his liberty or property, absent trial by jury, according to the law of the land. The law of the land is our common law heritage. That came before the Constitution, came before the Articles of Confederation. Those are where all our rights arose from. It is also enshrined in the Constitution under due process. One of the things about due process we don't see today in the courts. We have what's called procedural due process, and any of you doctors out there will know that as long as the medical board or whatever board you're dealing with follows procedures correctly, they're going to win every time. If they fail at that procedure, you will win it if you acknowledge that they have failed at the procedure. But under common law, if by presumption a man is found guilty by that presumption, it is a violation of due process. Every fact must be proven against him. Nothing can be alleged. Nothing can be on circumstantial evidence. It is called the solemnity of the law, and that's what real due process is all about. Let me move to the next screen. Okay, from John Locke. John Locke was actually credited with establishing that what we have in our constitutions today is a public trust. Now, in here, John Locke is talking about a social compact. Social compact is strictly for the states into the United States, the nation. And it says, let's see here, the law of nature, which indeed is the eternal law of the Creator, infused in the hearts of the creatures at the time of His creation, was 2,000 years before laws written and before any judicial or municipal laws. What that is stating is that we have these natural rights within us. And what we have given up are those natural rights to fall under the state. And that's not what the state was created for. The state was only to protect these rights that John Locke is talking about. But it hasn't. It has put restraints upon restraints upon restraints. Every art that a man practices today is restrained by either license or by regulation. Okay. The law of nature and of nature's God are the foundations for unalienable rights. The word unalienable may be defined as that which is not alienable nor transferable. Unalienable rights, again, are those rights that you're born with. They are your birthright. They give you the right to do anything you wish, build anything you want, providing you do not injure another. It is said that a man has a duty to protect the rights in others as that other man has the duty to protect the rights in him. So that is the limit of what government can practice upon us. It can only restrain us if we are violating the rights of another. That's what government is created for. The rights of the individual are not derived from governmental agencies, either municipal, state, federal, or even from the Constitution, but they exist inherently in every man and are merely reaffirmed in the Constitution and restricted only to the extent they have been voluntarily surrendered by the citizenship to the agencies of government. Now, you may say that this is a correct statement, but it is not. Unalienable rights are immutable. They cannot be given away by consent. What is being discussed here is inalienable rights. Inalienable rights are rights that one has within himself unless he consents to remove one of those rights and delegate it to someone else. The only time that has ever happened in this country was at the dawn of the country when we created the three branches of government. We did consent to delegate part of our power to all three branches, the judicial, the Congress, and the executive branch, or in the state, the legislative branch. But that's the only time we have done it, but we retain it within ourselves in times of emergency. It is not totally given over to the state or to the United States. Those are our powers, and And those come with being the human by under a creator. Having a creator endow you with all those rights. So the transfer of delegations of powers are limited to the aspect they're being used properly. Otherwise, we have the right to retrieve them. For example, if you're being robbed on the sidewalk and there's a law against carrying a gun, and you have a gun on you, do you have the right to use that gun to protect yourself? Most certainly you do. That's a right that you don't have to depend on the police who are not there to protect you. You have a right to depend on the power within yourself at that point. A man may not barter away his life, freedom, or substantial rights. That's true. That's called unalienable rights. Inalienable versus unalienable. Inalienable rights, rights which are not capable of being surrendered or transferred without consent of the one possessing such rights. Now, this inalienable came about in about the 18th century, where I forget the name of the guy that argued it in the courtroom, but he said that if a man were to consent to removing a certain right from himself, that would be inalienable rights. Well, that's not a true statement, because that would say that you have a right to give away something that's endowed, inherited within yourself, innate in yourself. You can't give it away. It's in you, not even by consent. Unalienable rights cannot be transferred even by consent. They are immutable. To the people of Congress, the President, and the Supreme Court of the United States, okay, let's hear it. The Constitution in its words is plain and intelligible, and it is meant for the homebred, unsophisticated understanding of our fellow citizens. The people alone are the absolute owners and uncontrollable movers of such sovereignty as human beings can claim to exercise, subject to the eternal and unchangeable rules of justice, of truth, and of good faith. The moral law is out of its reach. Sovereignty cannot violate that and be more justified than the humblest individual. Yield away the Constitution and the Union, and where are we? Frittered into fragments and not able to claim one portion of the past as peculiarly our own. Our union is not merely a blessing, it is a political necessity. We cannot exist without it. I mean that all of existence which is worth having must depart with it. Our liberties could not endure the incessant conflicts of civil and conterminous strife. Our independence would be unreal mockery. Our very memories would be turned to bitterness. So the Constitution itself is in place purely to protect our interests. The Constitution is in the states are created in two subdivisions. The first is the delegations of rights. That's where we have those rights from God. And then the second subdivision is the delegations of powers. So we relinquish part of our powers to the second, so we are protected by the capacity of the offices and the appointing and elected officials that we've delegated that power to. That is the limit of government. It is purely to use the power we've given them to protect our powers in the first instance. And I believe I said this in the last webinar, is that the first subdivision of the Constitution can stand alone. It's independent because it is us. It is our powers. It is what we are. The second is created by us. It cannot stand alone. Without us being the delegation of powers to that second half, it will simply collapse. Please note that by implication, your use of Federal Reserve notes has lifted you off the land and your direct access to the law of the land. So first order of business is to go after the currency. We covered that in the first webinar. I'll go over that just a little bit. The actual gold coins and silver coins that we had come from the treasury of God, if you would like to see it like that. It's dug out of the ground, it's dug out of caves, wherever you get it, it is the treasury of God, and once it's put into your pocket, it's movable land. And attached to that movable land, and attached to the land you survive on, grow your food on, feed your family, clothe yourself, are all the rights you need, the immutable rights. But when you change the nature of that immutable land, that land that's movable, I should say, and put it into flat paper currency, the flat paper currency is created on the seas. It's called negotiable instruments in commerce. Commerce has to deal with navigation, contract on the high seas in the time of war, and contract on the high seas in time of peace is maritime. Admiralty, war, maritime, peace. So when you're using these Federal Reserve notes, you basically have moved yourself, distanced yourself from the land where your rights are. Now you have a new set of rights called privileges and immunities. You fall under that 14th Amendment citizenship of the United States. And if you've read the book, They Own It All, Including You, you'll see that that 14th Amendment and that type of citizen is created on the high seas. It's right there from the Lex Mercatorium.
Ron, forgive me for interrupting, but I want to point out that when Admiralty law is essentially the same thing as administrative law, and all of the doctors on this understand administrative law because they're subject to medical boards, which we're getting to momentarily.
Yeah, well, that's a very valid point, Robert. And Admiralty law is when the admiral can adjudicate, can legislate, and enforce the laws that he puts over his fleet. Administrative law is when the bureau or the agency can adjudicate, legislate, and enforce the laws they create. It's all centralized in difference to decentralized. Decentralized is how we created our government. A separate and distinct Congress, a separate and distinct judicial branch, and a separate and distinct executive branch. Well, these administrators have all those powers into one package. The power of the office is tremendous. It blows everyone away because the person who comes up against the power where the person he's dealing with has created the very law and is enforcing the very law and adjudicating the very law, what do you think will be the outcome of any hearing that you go to under those conditions? Not favorable. Fundamental principles of unalienable rights. The right to contract cannot be abridged except that you cannot contract to abridge the rights of others. Well, these are all basically rights that we have as citizens on the land. They're not necessarily the rights that we have on the sea. On the sea, these become procedural. They have to fall in to administrative regulatory laws. So we're guided through regulatory laws, and as a fact, the only time regulatory law was put into this country was during the Revolutionary Law, and I believe it was Massachusetts suspended the law and replaced it by regulatory law, which was by ruler, is because it was yet undetermined what type of law we would have in this country. So when we're seeing regulatory law in our lives, we have suspended the Constitution for that. Law no longer exists. And when you have a hearing in an administrative board, such as a medical board or something like that, and you appeal it and you go into a court, the court only becomes a reviewing court of administrative law. You never touch the law any longer. It's without our grasp.
Ron, that last slide was really important.
Okay, let me, oh, did I pass a slide out? Okay,
Go back
sorry
one
about
more.
that. Yeah, another one?
No, one more. Go back one more. That's it.
Oh, okay. Oh, I didn't know that was an error there. Okay. Cannot change the meaning of words. This is a very important case that I came across. And I'm going to read it right from the beginning. Assuming that, well, I'm going to stop there. This case deals with the interpretation of law as it stands. And it says, a law and its application can only be changed by Congress either by the abolition of the old law and the passage of a new law, or by an amendment of the old law, clearly showing that Congress intended for the law to have a new meaning. We cannot wish a new interpretation into a law or give it a new application merely because the situation which caused its passage had ceased to exist. I'm going to give you an example. At the dawn of this country, the word revenue meant gain on rents of property. That's what it meant. If the Congress wanted it to mean more, such as income tax on labor or your income or anything like that. They needed to abolish the law of revenue back then and build a new structure, construct a new law to fit in income, which they have not. And the reason they have not is because, even though they have a Title 26, is because they can't change the nature of the country that pre-existed before the Constitution was created. Those words have the same meaning back then as they should have today. And this case actually proves that they reinterpreted those laws, revenue laws, and things of that nature, in spite of that they had no authority to do so. I hope that is clear to everyone.
I'll make it a little bit clearer. While Ron talked about revenue, the word income in early English dictionaries from the late 1700s defined income as what you made your profit on rent or property. It had nothing to do with the labor of your hands. Now, that's not where Ron and I are going with any of this. We're not taking on the income tax laws, don't get me wrong, but this applies to one key word that holds sway over everything that's going on, and that word is dollar. A dollar was defined clearly in early American law as a fixed weight of gold or silver. It's in the Constitution, it's in state constitutions, it's in Webster's 1928 dictionary, and it's in every law dictionary prior to the introduction of the Federal Reserve note, where dollar meant a fixed weight of gold or silver. So please look at this slide, and you will see that this came from a court case in 1951, a modern case which is specifically saying that you have to use the definition of words when the law or the Constitution was adopted. I'm done.
Okay. It's a very important case. Okay, in this one, a law that punishes a citizen for an innocent action, or in other words, for an act which, when done, was in violation of no existing law, a law that destroys or impairs the lawful private contracts of citizens, a law that makes a man a judge in his own case, or a law that takes property from a person A and gives it to D, is contrary to the great first principle of social compact and cannot be considered as a rightful exercise of legislative authority. Social compact is correlated or related to the United States Constitution. Public trust is to your state constitution. So you can see here, it denies that the state or the federal government ever had the power to take from A and give to D. That's your welfare state, isn't it? So that's a power that they actually have never had, and they're abusing the power, but how they're doing it is under this quasi-fourth branch of government called administrative law. So that has to be attacked in the future of what we're doing. Now, regarding licensure, key case defining our unalienable rights. When a health law is challenged as unconstitutional on the ground that it is arbitrarily interferes with personal liberty and private property without due process of law, the court must be able to see that it has, at least in fact, some relation to the public health, and that the public health is the end actual aim at, and that it is appropriate and adapted to that end. Under the guise of police regulations, personal rights and private property cannot be arbitrarily invaded, and the determination of the legislature is not final or conclusive. Okay, what they're saying here is that many of you doctors out there may be practicing privately and doing your thing with your patients, treating them or whatever. As long as you're not injuring anyone, or even if you injure someone, does it injure the public health as a whole? Well, no, it doesn't. So the police powers cannot pertain to the individual actions of the individual. So that is what the police powers are all about. If they create a police power that is limited to a class of citizens, they violated constitutional principles on that. It has to apply to every citizen across the board, and we're going to get into that. Did I pass up a frame, Robert?
Yeah, actually, I was cut off for about a minute and a half there, Ron.
Let me
So-
back. Okay, we're on the next one then. Hold on to your hats. Okay, Robert wrote these titles. Okay, so the police powers can be exercised only for public objects, and not as part of personal regimen or health. The legislature has no authority to take away a person's property or control its enjoyment merely because, in its opinion, its use may prove injurious to such people. The police powers can be exercised only for public objects and not as a part of personal regimen or health. The legislature has no authority to take away a person's property or control its enjoyment merely because, in its opinion, its use may prove injurious to such a person. Okay? You have a license. Yours is in the field of alternative medicine or contemporary medicine or what have you. Does the state, under legitimate police powers, have the right to take a license away from you? First of all, I'm going to say they don't have a right to license you in the first place, but let's pretend that they do. Do they have a right to take the license away from you individually? No, they don't. If you're not affecting the public at large, they can't touch that license under a constitutional police power. That's in violation of the authority they've been given here. But however, let's say that you have a nuclear plant that you built on your property, and it's starting to leak radiation. Do they have the right under police powers to shut that down, to take that property from you? Well, certainly they do, because you're affecting the entire population at that point. Okay, did you want to take this, Robert? This is...
Yeah, I can. Are you able to hear me, Ron?
Yeah, I can hear you loud and clear.
Okay. Yeah, I was cut off for 2 minutes, and I don't know why. I thought the whole webinar
I shut you off. I shut you off, Robert. No, I didn't.
Sounds like you. All right. Read. We have a lot of alternative docs on here. So read this first sentence. The constitutional guarantee that no person shall be deprived of his property without due process of law may be violated without the taking of property for public or private use. Property could be destroyed or its value annihilated. Realize your labor, your intellectual property, your use of chelation, your use of ozone, in the case of Brad Weeks in Washington State, he's using, his license was revoked for alleged, the theoretical risk of harm to a patient for growth hormone. A theoretical risk. Nothing happened. What you're reading in this case, and several others that I have that Ron might be able to flash up on his screen because I just sent it to him, is that the state can't move on your property, your intellectual property, or your rights unless it's affecting the public as a whole. If you're just there with a patient, or even 2 patients, or 3 patients, and what you're doing is not affecting society as a whole, what the government is doing is void. It says here, when a law annihilates the value of property and strips it of its attributes, the owner is deprived of it according to the plainest interpretation. And
Is this the one? Is this what you're looking for?
Police power. Let's go through that because the doctors need to see that. Ron, look at the first one in red.
Okay. Police power regulations must be substantially related to the advancement of public health, safety, morals, or general welfare. See Village of Euclid. That's the case on that. Let's see here. Let me go down a little bit.
So scroll down a little bit so they can see these additional cases.
But neither the amendment or what you went over this, Robert. Do you know which ones you want to?
Yeah, keep going. I got it in red, Ron. Keep going.
Oh, okay.
You'll see more.
Okay. Insofar as the police power is utilized by a state, the means employed to effect its exercise can be neither arbitrary nor oppressive, but must bear a real and substantial relation to an end which is public, specifically the public health, public safety, or the public morals, or some other phase of the general welfare.
Now, I want to raise here, that word is public. When you have a patient coming to you, you're in private contract with another human being. That is not a public issue. Scroll down some more, Ron. I think we got a couple others on point here.
The state cannot deprive the citizen of the lawful use of his property if it does not injuriously affect others.
Oh, whoa. Now listen, Brad Weeks, I don't know if you're on the line, but did you hurt someone else? Is there I mean, you're going to see here in one of the things that I've highlighted is that the simple existence of a brewery or beer in vats in private property just sitting there doesn't affect the public. Go ahead, continue reading, Ron.
There's one thing to note on this. The license itself does not belong to you. It belongs to the state. However, when the state revokes the license, it revokes your power to access your property called your education and use those skills as you would normally use as any individual within the country. Okay, so did you read this? The constitutional guarantee of life, liberty, and pursuit of happiness is not limited by the temporary caprice of a present majority and can
that would
be
mean
limited.
the medical board. The present majority would mean the medical board.
Yeah, be limited only by the absolute necessities of the public. So, yeah, and here we have a majority versus the individual. The purpose of the constitutions of the state and of the United States is to protect the individual's rights. Not what the majority wants, but what the individual wants, because in the majority are individuals, and all their thought processes are probably different from each other. But each of them have rights. So the whole purpose is to protect those rights in the individual. And we're not having that. We're having boards and bureaus and commissions destroying people over unconstitutional police powers that take away what you think you own, a license, whether it's a driver's license, a contractor's license, or a doctor's license. They're taking them away and destroying all your education that you labored for over the years. That's your property. They don't have a right to do that.
Ron, scroll. I want to see the other page that you just went past. Scroll up a little bit. Stop. Right there. No, where it was in blue. There was a blue paragraph.
In blue, there it is.
Yes. All right. I want to point this out. I want to read the blue one and then the next one. No proposition is more firmly established than that the citizen has a right to and adopt and follow such lawful, that means common law, and being a physician has always been in the common law. You can go back to Hippocrates to know that. It's a common law profession. And then it continues, and industrial pursuit not injurious to the community as he may see fit. Let me reread that. I'm going to paraphrase it. The most concrete proposition is that the citizen has the right to follow any lawful pursuit that's not injurious to the community, meaning the public, as he may see fit. So go to the next sentence. The mere existence of a brewery in operation or of beer in vats not intended for consumption in the state is not in any way detrimental to the safety, health, or morals of the people of Kansas. That's got relevance to us as physicians. This has got, I mean, you go back to the previous paragraph and it says not injurious to the community. And we are being deprived of our ability to heal and serve people when there clearly has been no injury.
And to go one step further, if you're in your private office and you do injure someone, and it's not, it doesn't cause the demise of the individual, that becomes a civil action. It's not subject to the state's overview of the case. It's a civil action between you and your patient. And that's how it was in the common law, but today they make it a public policy that if you injure someone in your office, that person goes to a medical board, he establishes a complaint, and all heck breaks loose on you.
And we know, and here not my legal hat is on, but my alternative medicine hat is on. We all know how many doctors have been rubbed out, literally their lives destroyed and their patients' welfare destroyed, simply because they were doing medicine that the other guys didn't believe in and there was no injury. That is so crucially important here. But even more crucial than that is, you can see from what we're presenting, and in the next couple slides, that the police power of the state is fully limited to protecting the public at whole. It's not, it doesn't come in between you and the private contract you have with the next person. Read this, Rob.
There is no more sacred right of citizenship than the right to pursue unmolested a lawful employment. Here the word lawful means common law preceding the Constitution. In a lawful manner. It is nothing more nor less than the sacred right of labor. That a law which should make it a crime for men either to live in or rent or sell their houses would violate the constitutional guarantee of personal liberty. That one could be deprived of his liberty in a constitutional sense without putting his person in confinement, and that a man's right to liberty included the right to exercise his faculties. Faculties are your talents. And to follow a lawful avocation for the support of life. See, these things were unlicensed or unrestrained. That's how it was in the common law. And government was never instituted to restrain the people in their arts, whatever they do to make a living.
And I can prove it to you really quickly, because one of the signers of the Declaration of Independence was a known physician, Dr. Benjamin Rush. He wasn't licensed, so we know that his rights to do his profession arose out of the common law. He had unalienable rights to treat people, and that at the time even included sticking needles in people, because they did. They bloodletted in those days.
Okay, in Potter's Dworis on statutes, this man is recognized as the core from which all police powers and their definings are given to countries. He's the one that developed this concept. It is said that the limit to exercise the police powers can only be this: the legislation must have reference to the comfort, the safety, or the welfare of society. It must not be in conflict with the provisions of the Constitution. Now, you notice they're using the term society. Comfort of society, safety of society, and welfare of society. They're not talking about in your neighborhood. They're not talking about in the city. They're talking about the society as a whole, the state. If something affects something in your neighborhood, it is not under the police powers. Again, that's civil action right there. That's where you're probably hauled into court if you did something wrong to your neighbor. The law will not allow rights of property to be invaded under the guise of a police regulation for the preservation of health or protection against the threatened nuisance. Is that important? You may have something going on in your office that the state's OSHA says, hey, that's not safe. They don't have a right to go in there. And when
I want you to think about this. There's probably some people on the line from California. The law will not allow the rights of property to be invaded under the guise of a police regulation for the preservation of health or protection against the threatened nuisance. And the courts will interfere to protect the rights of the citizen. In California right now, there's a criminal statute that says if you don't treat somebody with chemotherapy, radiation, or surgery, you're a criminal if he's got cancer. Wait a minute. That's an abject violation of the principles that you're reading right here.
And I believe it's all right if I say you were attacked by OSHA, and with one letter, they went away. Am I correct, Robert?
That's true.
Okay. And when it appears that such is not the real object and purpose of the regulations, courts will interfere to protect the rights of the citizen. The police power is not without limitations, and that in its exercise, the legislature must respect the great fundamental rights guaranteed by the Constitution. If this were otherwise, the power of the legislature would be practically without limitations. In the assumed exercise of police powers in the interest of the health, the welfare, and the safety of the public, every right of the citizen must be invaded and every constitutional barrier swept away. So they're not granted unlimited powers in the police powers, as you can see. That's never been the goal of the state and its power to police the entire society. It doesn't have the right to go on an aspect of a class of citizen or a group of people doing whatever they're doing. They're supposed to leave that alone. It's supposed to be for the comfort of the entire society. Must affect the public at large, not just some person. To justify this law, it would not be sufficient that the use of tobacco may, well, let's skip that part right there. When a health law is challenged in the courts as unconstitutional on the grounds that it arbitrarily interferes with personal liberty and private property without due process of law, the court must be able to see that it has at least in fact some relation to the public health, that the public health is the end actual aim at, and that it is appropriate and adapted to that end. Robert, I know you want to get in on this one.
Oh my God, do I want to get on this one. It says here at the top, to justify this law, it would not be sufficient that the use of tobacco may be injurious to some persons. That comes out of the case. Let's go now to Maureen Long in Oklahoma, who was just totally wiped out by the federal government because she was using Laetrile for cancer. Well, first of all, they can't even prove that Laetrile is harmful or that she harms someone. So that law is absolutely void on its face on the grounds of unalienable rights. If she argues the facts, she's dead. But here you can see, yes, tobacco could be injurious to some people. We're not going to argue with that. And you know something? Maybe it's theoretically possible that high-dose vitamin C could hurt someone. I'm not going to say that can't happen. Maybe it could scar a vein. Maybe 1 in 10,000 people will get a kidney stone. Is that reason to stop its practice because you're in a contract with that one person, and you are in the common law responsible to that one person? No, it doesn't affect the public at large. Please note the Rowan McDonald note at the bottom. An example affecting the public health would be someone entering the jurisdiction of the state or the community with smallpox. Then the entire population is threatened, and yes, the police powers of the state could step in then, but not into your office giving vitamin C, chelation, oxidation, or an herb, or any of the homeopathics that the government has just rubbed out. I had to get my 2 cents in.
I knew you had to. But, you know, I have to mention that the reason this is all happening is because the nature of the currency in the United States, and we'll get into that, if not today, at the seminar. But that is directly linked to why the police powers have gone haywire in this country. Key Supreme Court case defining the federal limits of commerce. The inspection laws, form a portion of the immense mass of legislation which embraces everything within the territory of a state, not surrendered to the general government, all which can be most advantageously exercised by the states themselves. Inspection laws, quarantine laws, health laws of every description, as well as laws for regulating the internal commerce of a state, and those which respect turnpike, roads, ferries, and etc. are component parts of the mass. As you can see, it's eliminating the federal government out of any health laws of any description. What's the FDA? What's the purpose of it? It's going in and telling you what you can do for the health of someone that you're caring for as a physician. They're not allowed to do that. This case actually stated that that authority goes to the state. And guess what? In the state, you vote for the system you want in the state. That's the way it was made. If you want laws in concerning health, you would put it in. But it would have to be most likely a unanimous vote to do something like that, because it would be, there could be a very division between alternative doctors and contemporary doctors. If the contemporary doctors were a majority of doctors, it would be lopsided. So it'd have to be by unanimous vote to put something in against health laws.
This was a Supreme Court case in the early 1800s, and you know, Ron, you and I have discussed this before, where people say, oh, laws are overturned, the Supreme Court pulls this crap all the time. But at our first webinar 2 weeks ago, you said, not necessarily. You have to go back to where the water is purest, and they knew then what the intent of the framers was.
Right, and it's not only that, you have to go back to the use of words at that time, the defining of the words at that time, because if you were to bring yourself back there and be one within the population in 1789 when the Constitution was enacted, you would understand what these words meant. You would understand that the federal government does not involve itself in the health of the state. That's a state issue. That's the population. When we say state, you could replace state with people. The people of California, the people of New Jersey, or whatever state you're in. That's what state meant at the time. So the federal government was not to have any authority over these things. But again, I have to direct your attention to the money issue, because it's the money issue that gives them the right. Because the money issue took you off the land where these rights are. But we have a way to get back there. It is declared in Section 2, Article 2 of our Constitution that no person shall be deprived of life, liberty, or property without due process of law. And again, the due process of law is talking about the common law. Not the current law of procedural due process, but the common law, where I said you could not be convicted of a presumption of law because it would violate your due process. It's the solemnity of the law, that everything that is alleged against you, every fact has to be proven. And Section 13 of the same article provides that private property shall not be taken or damaged for public use without just compensation. The word due process of law in this connection are held to be synonymous with the words the law of the land. And that's Cooley. He's written many books on the constitutional limitations. And this means general public law binding upon all members of the community under all circumstances, and not partial or private laws affecting the rights of private individuals or classes of individuals. Everyone in the room who's a doctor, raise your hand, because you're a class of individuals. So this shouldn't pertain to you. The laws that are out there today cannot be instituted for a class of citizen.
And please notice here, law of the land, common law. If you are within the law of the land or the common law, then you're in possession of all of your unalienable rights, and they can't do these things to us. This is making this really clear here. And they can't make laws affecting the rights of private individuals. You know, let me tell you how bad this is. I was recently slapped by the California Medical Board, and I'm going to tell you the whole story because Ron was there. Is it a good story, Ron?
Yeah, it is.
All right. There was a complaint against me. It was a bogus complaint. I didn't want to turn over the record because the patient signed a contract that we were operating out of the outside the purview of the state. He signed that contract, and his wife was a witness. She signed it too. He ended up dying because he didn't come back to me. They broke the appointment. They went somewhere else. And then months later, she files a complaint that I abandoned the patient and I contributed to his death, which was all shit. Well, I didn't.
He died Robert, he died 6 months later. After he stopped seeing you, he died 6 months later.
Yeah, and he came to me with liver cancer. His body was riddled with cancer. He was near death, and he still lived 6 months. But the point is, they broke the appointment. They didn't come back, and she accused me of abandonment and negligence. So Gary knows about this case. I posted it on his website. So let me tell you what happened that you need to know about. And this is why private medical associations will fail. They wanted the record. I said, you can't have it. This man signed a contract with me and witnessed by his wife, the complainant, that the record was sacrosanct. And I didn't hear back from them until 2 months later when they slapped me with a $1,000 citation for not giving them the record. And I said, you can't do this. And so I requested an informal hearing. And by the way, this was not disciplinary action. This was like a speeding ticket. It was a citation. So Ron went with me, and it was a very pleasant woman who actually felt for me. But she said, you know, Dr. Rowan, you can't win this, and here's why. And she said, you need to know you can't contract with a patient to do this. I said, what? And I said, no, I don't know about this. So she said, well, I'm going to be kind to you today. I will go get you the law. So she goes out, gets a book with the medical codes of California, something I had never seen. And it's true. A licensee in this state, and probably in many other states, cannot contract with their patient to keep the purview of the case outside of the medical board. And I just sunk in my chair. I couldn't believe it, because to me that violated the rights of contract, everything else. And I turned to Ron, and both of us knew I had been defeated. Right, Ron?
Yeah,
I was the one. I was the one holding the license. I was the one subject to this. So I said to her, "You win. I surrender." So she was really, really nice to me, and we negotiated the citation down from $1,000 to $400. Which I gladly paid because there was no way out of it. And on the way home, I said to Ron, "Hey, Ron, how do you feel now knowing that you can't come to me as a patient and me your physician and keep your records sacred from the medical board?" What was your comment, Ron?
I forget, Robert. It's been so long.
You were shocked that your right to contract with me was blown away.
Yeah. So I had the ability to attack the medical board on that aspect of it.
But not
I
me.
have a right to, yeah, but not you. See, and we're going to get into that at the seminar. This is the right under a common cause. If I have a right being lost in any administrative proceedings or judicial proceedings, and I'm not party to that proceedings, I have a right to join it, because if I have a right to that would be lost by the outcome of the proceeding, I can go in there and I can argue the law in the case, saying that it cannot apply because it violates my rights.
Now, Ron, we're probably approaching the hour, and people are wondering, yes, we see this, and we understand they're doing things they can't do, and we can show more of that in the coming slides. But just in case people have to leave, why don't you talk to them for a few minutes about the remedy we're going to be bringing forward after we first deal with the currency, because I think by now they know if you're dealing with their currency, you're subject to their laws. So the currency comes first, but tell them what we're going to do second in the state Supreme Courts regarding licensing.
Yeah, well, maybe we should go right to the end of the slides, Robert, because
Okay.
let me
Go ahead.
and they can read this at Gary's website. Here's the case I did for an individual. It was the state contractors board moving against Louis G. Berry. Louis G. Berry was ex-mayor of Rohnert Park, a very plush area up in Northern California, and also a plastering and drywall contractor. He refused to take out state taxes of his employees, and he had several of them. And when the state found out about it, they informed the contractors license board. They attached a lien to him or something else like that. And the contractors board revoked his drywall license. So at that point, he came and saw me. Well, not at that point. I should say he did it for another 2 years after that administrative process. And he was caught again. So now we have the Attorney General of the state, Bill Lockyer, defending the Contractors Board, moving against Mr. Berry for not paying franchise tax board taxes. And that's when I came into the picture. and I looked at his case, and as you can see, the caption up there says, "In the matter of citation against Louis Berry." Now, in this case, in this caption, you'll notice it doesn't have the people of the state of California. It doesn't say who's actually moving against him. And you know, with the Attorney General, he should always be involved with the people of the state of California moving against someone. But this is an administrative process, so the people are excluded from it. Well, that in itself is a violation of fundamental principles, but I'm not gonna address that today. During this process, I proved to Bill Lockyer that he had no rights over this man, that he could not attack this man, because this man doesn't fall under the special laws of the Contractor State License Board, nor under the Franchise Tax Board's laws. Now, that's the most powerful agency in the state of California. The Franchise Tax Board is more vicious than even the Internal Revenue Service, as many people will tell you. So what I did is I researched the laws, and I found that every statute, every code, every regulations in the state of California were copyrighted. Now, most people don't think much of copyright, but the copyright holder has the right to amend those laws, has the right to abolish those laws. It's within his powers because he owns those laws. And what I did is I pulled up a case. I was currently within the appellate court over a group of people that own the fire codes of all of the United States, and they're not even officers of any state. They owned them outright. And what happens is they give them to, let's say, the state of California. They adopt them into law. Well, that's a violation of the procedure how laws are to be instituted in a state. They have to go through the House and the Senate, and have to be, it's a bill, you know, and it has to be passed by the government or governor, and then he has to either veto it or accept it, sign it. Then it has to be promulgated and everything else. Well, when I put this case together, it was so tight that when the Attorney General, Bill Lockyer, read it, this is what he did next. Withdrawal of citation. Dear Judge Crowell, the Contractor State License Board is withdrawing the above referenced citation. Please take this matter off calendar. It is currently set for Tuesday, July 24, 2001 at Oakland Office of Administrator Michael B. Franklin, Deputy Attorney General, for Bill Lockyer, Attorney General. They were so frightened of this case that I put together, this brief I put together, they withdrew. And what does that mean, withdrew? They didn't dismiss the case. They withdrew. They ran. And what ran from me was the entire state of California. They basically backed off and hid on this issue. They didn't want this issue getting out there. Now, this was licensure. This was all about licensure. And, of course, in that substance of that was not only copyright, it was about the licensure, because that's a special class of citizen, just as a license for a doctor. There's no difference. One might appear to be more prestigious than the other, but basically the licenses are the same. So that's what it was. And the next slide is where the Contractors License Board, they didn't believe what Bill Lockyer was doing, the Attorney General. They thought that possibly it was just it was a continuance. But what they wrote several months later was, please take notice the above caption citation is hereby withdrawn in its entirety. So they basically retreated. And that's what happens with the license law. And of course, imagine taking down your franchise tax board and telling them, I'm not paying the taxes. Well, that's what happened here. You have comments, Robert?
Yeah, so here you can see, you know, there's really no difference between a contractor's license and a physician's license. It's all the same thing. The state is commanding you to have a license to build a house or put up drywall or whatever. And the state is commanding us to have a license to treat people. There's no difference. One small difference is, and Ron and I will address this at the seminar, he can get his materials, I can go and get contracting materials without a license. You can't get a lot of medical materials without a license, but that's something we're going to address. But here, the state of California ran from this and withdrew it because they did not want a record of this anywhere in the public. You will never, ever find this anywhere. Had it been dismissed, there would have been a record of it. But now it's been withdrawn, so the paperwork doesn't exist. You can't find it. Correct?
Yeah, absolutely. And there were other cases. I mean, even with the tax case that I did, where there were liens and they were trying to, the IRS was coming in to take possession of the properties. I moved against the recorder's office of the county where the property was situated for a violation of law by the IRS. They did not sign to certify that the money on the levy or lien was proper. So what happened is the county actually took the case and added the Internal Revenue onto it, made it a federal case, and it had nothing to do with the federal government, and moved it into the district court under Judge Chesney. So I drew up paperwork for the individual's son, and I moved him into the court under a common cause, as we'll address in the seminar. And under that common cause, I had him, first of all, to stop the Anti-Injunction Act, because anyone that goes into tax court or any type of court and addresses the law in a tax case, the Anti-Injunction Act comes right into it. They'll stop you from discussing the law.
In other words, the Anti-Injunction Act says that you can't contest the collection of the tax or any law surrounding it until you actually pay the tax. Then you can.
Now, it was just me and this gentleman in the court, and when the Judge Chesney asked the man, who did this paperwork? You didn't do this. This is legalese. And he pointed back to me, and she says, are you telling me that you can move here in this court because you have a right that's being lost in here? And she said, oh my God. And then when the deputy attorney stood up for the government, he says, well, we're invoking the Anti-Injunction Act. She says, shut up, sit down, you cannot in this one. She was fearful of this. She remanded it right back to the state. She did not want it in her courtroom. Imagine what that would do across this country if people knew that. That all you need is someone else to come into your case because you have a right to lose. And that doesn't matter if it's an IRS case, it doesn't matter if it's a DUI case or ticket case, whatever. You have the right as the interested party, the real party in interest, to protect your right if someone is found guilty in that case. You can join any case you want. I've said my piece, Robert.
Oh, okay. Well, maybe people might have questions, they can type a question in, and we have.
Okay, how do I get back to the?
I think that's the end of the slideshow, but I have a comment. All of you who are on here, please know that we're having a seminar on this, August 10th and 11th at San Francisco Airport. You can email me if you don't have any means to get more information. My email address is drrowen, D-R-R-O-W-E-N, @att.net. Ron and I need you. We can't do this ourselves. We need you. We need things like this to go viral across the land, because the first order of business is to restore a lawful currency so we can get back on the land, meaning common law, and then move to restore our common law rights where we don't need a license and to answer to the arbitrary and capricious powers of a malevolent medical board. We have shown you that this can be done.
I should say at the seminar we have a writ of prohibition and alternate writ of mandamus. And prohibition means to prohibit someone. Mandamus is to compel someone to do a duty. So in this, it's a very unique instrument in that how we're doing this to stop the federal government from entering into the state cannot be questioned by the Supreme Court. They have to follow the law in this matter. So, and what we're doing is shutting out the federal government from the state. So if you're interested, and that stops the money. And we don't get the money back as far as redeemability, not as yet, but the only alternative for the federal government is to start redeeming the money.
And then once the currency is done, we plan to have petitions to go to the Supreme Court of every state for every one of you who are affected by licensing to ask for a writ of prohibition from the Supreme Court to stop the medical, to want to do one of two things. Either stop the medical board from moving against you in violation of the principles that you just saw, or eliminate this issue of licensing altogether and return you to your common law rights. It has to be one or the other.
Yeah, and all it has to do is be one writ of prohibition, and everyone else joins on a common cause because they have a right to lose.
This affects all professions. This isn't just medicals. It affects contractors, hairdressers, barbers, plumbers, everybody who is compelled to have a license by the state. This affects supplement makers, compounding pharmacists, because we're dealing with God-given, unalienable rights. And the state has moved on that. And the people who are on this who are compounders, the people who are selling supplements, you're in big trouble. You know it. You're going to be wiped out within a year or two, either by total abolition of the industry or by a regulatory hell. And we don't belong in that regulatory nightmare, as we have shown you. So there is a way out of this. We need you.
So any questions?
Please type in a question. Gary, I would be open to opening up the microphone if people want to ask us questions openly.
I don't know if we're able to we can only put presenters on, but they can type in, and we could, I think it's useful to explain again. The first case that I started to mention in very brief outline is that when Ron prepares the papers, as the judge said, who prepared these papers? Well, if we're lucky, we could clone Ron McDonald, but we haven't figured out how to do that yet. And since we don't know how to clone Ronald McDonald, it's up to us to bring our intelligent family members, our motivated staff, those that want to help learn these regulations, because as you will see, if you had the ability to write, as Ron is showing you here, there isn't any of these inconveniences from the taxing authorities to the licensing boards that we can't stop, and we can bring back the power of the state. But you cannot do it by expecting someone else to do it for you. And I have to tell you that it's amazing that as many of you have shown up on a Friday afternoon as have shown, but you have to recognize everybody goes home and complains about how impossible it has gotten to be right now. As a supplement company's consultant, we find that our manufacturer virtually is prevented from releasing the supplements that we use to keep my clients and patients alive, because they have passed regulations that says it's not enough to know that the product has got ginkgo biloba or garlic in it. You have to identify in detail every one of the peaks that are found in natural materials. Well, that's pretty simple if you're selling drugs, because in drugs there's only going to be one clean peak. But when you start dealing with complex natural materials, they have been able to prevent for 8 weeks the release of the products that we call beyond chelation to our doctors who use it instead of bypass surgery to keep patients alive. So what Robert Rowan just told you is this is not an idle threat. Please know that regulation hell is put Gary Osborne with his wonderful pharmacy that he had, Apothecare, is no longer in business. We don't have those wonderful products that he was making. And he had knowledge that is his God-given right to have, and now you don't have the benefit of that knowledge. Unfortunately, people like he and Dr. Brad Weeks and others did not have the knowledge that is now coming, unfortunately, just the first week of August, August 10 and 11, those who come to San Francisco are going to be given the relevant laws. And if we could clone Ronald McDonald, yes, every one of us would love him to go and save us and prepare our saving. But we need to take the knowledge he's showing us that has not failed in a single case. I took the most egregious case, the guy I told you that had to go to jail. If I tell you the details on it, you'll understand that it was an open and shut slam dunk. He had to go to jail, and as you've heard here, they simply dismissed the case.
Yeah, he actually was caught driving without on a revoked license and without registration on his vehicle. So they had him dead to right. But at the end, what I proved at the end, two deputy district attorneys stood up and said, Your Honor, the people of the state moved to dismiss this case for lack of evidence. and it was, what I did is I took the notice to appear that everyone gets as a ticket, and I destroyed it, showing them that it could not apply.
So everybody listening to us right now, please understand that it is not our desire to empower the few of you who come so that you can do things that our friends cannot do, as Robert Rowan is clearly beating OSHA and is clearly keeping his state medical board at bay. We don't want to have just a few with the power. It is our desire. And the reason we're asking the money that we're asking to have you attend San Francisco. And if that money is stopping important people from being there, they will make special arrangements. But the money is needed if we're going to go ahead and grow this movement to something that can help rescue our country, because the regulation hell is bringing our country to its knees, to a total standstill, the economy. So please understand, the reason they're asking for a contribution when you come to San Francisco is because there isn't a law firm. This is coming out of the back of a very busy doctor, Robert Rowan, who I don't know how he has the time to run his medical life and still work with Ronald McDonald, because without Ronald McDonald, there is none of this legal research going. There isn't any attorney that you could find that will be able to find fault with everything or anything that we've said here. And the reason we've recorded it today is to give you a hint, because your attorneys are going to tell you that we are just smoking pot. There's no such way that government will turn their head and say, case dismissed, but it's happening, and it could happen to you, but we're not here just to rescue you. We want to rescue America.
Gary, we have a question from somebody which is relevant. A person sent a question saying they always say no one can, quote, represent another without a license to practice law. Okay, that's true. But the point is, when you are in that kind of situation, you are in their court, an admiralty court. And what we're trying to do, one of the things that we're trying to fix is not only the licensing for doctors and get rid of it, but open it up so that you can pick whoever you want to represent you, because that's your God-given common law right.
Yeah, but understand one thing, and this is where the common cause comes in. Maybe you can't have someone representing you, but if someone joins into the case, they can represent the right that you're going to lose besides their right they're going to lose. So in effect, indirectly, you are having someone doing this. And I'm not opposing that you go into any administrative hearing alone. I say get fellow members of your industry to go in with you to show the right that you're losing. And if have to, transfer it into a superior court, get it out of the administrative process. Go into the law first.
In other words, what Ron is saying is, if you're being attacked by a medical board, and it's just between you, Goliath, you're David, and Goliath, your patient is about to lose a right, an unalienable right. Your patient has the right to, see, you can't necessarily go to superior court, because the superior court is only going to look at the procedural due process.
No, wait a minute, Robert. Wait a minute. No, if you turn around and put a complaint into the superior court, you actually can pull the medical board in there, and less information and evidence can be put into the court by the medical board. So you can have opinion moving against you in the medical board, but in the Superior Court, there are stringent rules of evidence. And that's where you really should defend, is in there, because that's where you're going to test the law against the administrative process. And especially jurisdiction and rights being lost.
And your patient would be able to go in also on a common cause because they're about to lose a right.
Yes.
But we need to make everybody understand that we don't want to get into the merits of cases. We want to argue standing.
Right.
And we have to make people understand that they are not on the land unless they own the correct American gold coin. I mean, there's so many pieces to this puzzle. If you don't do each step of the puzzle, you will not walk out victorious.
Okay, I think, oh wait, see, there's one other one here. Let's see, you have to understand law yourself or you get railroaded by the judge verbally. Ron, you want to comment on that?
Can you repeat that? I don't see it on my screen, so repeat that question, Robert.
All right, I see it. It says you have to understand law yourself or you get railroaded by the judge verbally.
Yeah, you do, and that's a true statement. Robert had a case that, how many attorneys was on it, Robert? 4 attorneys? And they told
there were at least 3 attorneys, and we told them what was going on, and none of them could do it.
None of them could do it, and then I did a writ of prohibition in there. You had a friend, actually filed it into the appellate court. Am I correct?
An attorney, yes, an attorney filed your petition into the appellate court. He said it was the most brilliant piece of legal work he had ever seen. Continue.
And one of the judges in the appellate court actually granted the writ, and that's all it takes is one. But the other 2 judges treated it like an appeal, which it was not. Well, apparently, and this happened on a Friday, on Labor Day weekend, I believe it was, and Monday was a holiday, but on the Friday, the judge of the Superior Court demanded that to your attorney there at the time to bring forward your financial statements. And this is before you even went to trial. So I knew he was corrupt. I knew that judge was corrupt. But on Tuesday, filed into the Superior Court record of the county was that writ of prohibition. And on Tuesday morning, when you appeared there, Robert, the judge said, it appears we have no jurisdiction over this case. And the judge, only to save face, asked for just a simple brief from both parties on this issue, and then he dismissed the case.
That is correct. It's a true story, and that was paperwork that you provided. Dealing with jurisdiction.
Jurisdiction only.
So people, please consider coming to the seminar. We're not making money on this. Believe me, we're not. We'll be happy to break even, maybe do a little bit more, but this has cost a lot to do this kind of legal research. And I just can't do it myself. Ron can't do it himself. It would really help us to have a turnout, and not only for monetary support, but we need people, because once this is done, we need all of you to go out to your states and file these petitions in the Supreme Court of your state, because the more states that tackle the application of the fraudulent reserve note to the 16th Amendment, the more attention it's going to get. So we need you there. We need people to just take this and make it go viral. And that's all I got to say.
Okay, and in this, in order for us to succeed, the sheriffs are pretty disgruntled about the federal government on the Second Amendment. So what Robert and I are going to do, because there's the Sheriff's Department and the Recorder's Office, are going to be respondents in this writ of prohibition, alternate writ of mandamus that we're doing. We're going to talk to the head of the sheriff. We're going to talk to the sheriff who's the head of the county in that respect. Tell him what we're going to do. We're going to get his feedback on it. Then we're going to go to the district attorney of the county and talk to him, show him what we're doing, and in the paperwork, it absolutely is a law that must be followed, that they have to do it, otherwise they're violating law and doing a criminal act. Show him what we're doing. Then we're going to go to the recorder's office and tell her or him what we're doing and show them what the law is, and if they proceed to continue with this, they're violating the law as interpreted by the Supreme Court of the United States. That's all we're doing. And I know we'll be successful, and they're going to shut that door to all liens, levies, writs of executions, and all the various instruments that the federal government can pass through that door, because that's the only door they can get through is that recorder's office. And that will stop the money system from attacking the people.
And I got to tell you something. When this came forth, which was only about 3 to 4 weeks ago to do this, maybe 5 weeks ago, I called Gary about it the next day, and Gary agreed that this was divinely inspired. Yes, Gary?
That's correct. There's no other way we could. Look how many people have looked for a way to save this great land, and we are immersed in regulatory hell. It's bringing us to our entire economy to a snail's pace, and we have answers. I want to make it clear that with what we are talking about filing, the IRS will not be able to take away your car, your house, your office, your bank account. We're talking about bringing back the power to the state and allowing this country to go back to what Ben Franklin said. We have given you an incredible opportunity if you can just keep it. And it's called a republic, and we haven't been able to keep it because we didn't do our homework. We can save it, and we can bring this country back.
Thanks for attending, everybody.
Yes, thank you very much.